afternoon again.
Good afternoon, AG. The case has been dismissed. You've asked for a cost of $2 million. Do you think that was really necessary?
Very necessary. As I said, I don't know of any electoral system in the world that will permit a person who is not contesting that election in that particular constituency to be on the ballot box, on the ballot paper. You have not entered the contest. How do you expect to become a contestant? So it's as simple as that. And up to now, the lawyers don't think the lawyer who appeared in this case doesn't seem to understand that, because I heard his closing arguments there in relation to costs, and he keep repeating the same thing over and over again.
Was this ruling anticipated given the arguments put throughout the case?
The ruling was anticipated. A proper ruling would always have been the one that the judge handed down. And I said so from the beginning. The case should never have been filed. I keep saying that all the time. As the judge pointed out, this framework of rules and the constitutional provisions have been there since 2000. So 25 years now we're operating under the same electoral framework, the same statutory framework, the same constitutional framework, without exception. You think 25 years would have passed and nobody would have seen this? This forward movement party is so brilliant. It's such a eureka moment. It should never have been filed. The stupidity of it is alarming. That is why it is an exceptional case. So, as I said, you can't be part of a contest that you are not formally entered. And that's what the case is about, trying to get on a ballot paper when you are not contesting the geographic constituency of that place. I don't understand how else you expect to win such a case. So I am happy that the court ruled in the manner in which it did. For whatever use will be made of it in the future, at least I can't see this point ever coming up again. But in Guyana, you can't put anything beyond these political parties. They file anything that seems to come to their head. So we have now added enrichment to our jurisprudence as it relates to Article 160, that has been the subject of multiple interpretations. And you know that we have not lost one of these cases. Not one have we lost. All these challenges. Is it? It must tell you a message. How is it that one side is winning all these cases before different judges, before different courts, all the way to the CCJ? It tells a story. I would like to think that I'm the bright one here, but I don't think that is it. I don't think that is it. Dennis knows that, has very little faith in my ability. But these cases, one after the other, they keep churning them out, and they expect different results. So I'm happy that the case was decided the way it did, and I'm a little disappointed that I didn't get more than $1 million in costs. Imagine they didn't even know that they have to name the Attorney General. You are suing for breach of the Constitution. It's elementary law. Elementary law that if you are alleging a constitutional violation, you must name the Attorney General. They didn't name me. I had to file an application to be joined. So $1 million in costs was awarded by the court to the Attorney General, and another $1 million to GCOM. I believe the judge was very, very kind. He should have awarded much more than that. And as I said, hopefully this will add to our jurisprudence. But you will hear that someone will come out here just now and tell you that they will appeal, and they'll be very, very confident. Then they will get licks at the Court of Appeal, and then you will hear they might blame the system. But that's the nature of the litigation system. It allows for appeal. And if any appeal comes, we will have to deal with it at the appellate level, and it may elevate itself all the way to the CCJ, where I hope that you will get a lot of costs.
Thank you so much, AG.
Okay.
Thank you.